you told her this is on the website, she needs a minute to see if this is actually if this is the order that was in effect, I think that is relevant, and I think I do need to consider it, but she needs to be able to figure that out for herself, you can't just read something.
Agreed.
So,
Yeah,
if you can, what I
Can we
need
take
you to
a brief
do.
recess so I can look myself, like I said, there's no exhibit list right now, I asked if he had an exhibit list, if he was planning to bring any exhibits into evidence, I was indicated it was not, so could we take a little time so I can look myself?
If that's what you wanna do, I mean, although I was gonna say I was gonna let him make his argument, and then you can
I would
file
prefer-
something if you
Yeah,
wanted to.
I think that's the best approach, we're already at 154.
Okay, I mean, I don't have hard stop at 2, and I confirm everybody else doesn't, but yes.
And Your Honor, based on the state's exhibit list, the presiding judge's statewide order on use of cameras and electronic devices in common areas of court facility is listed as number 2. I didn't know she'd be using one that was inapplicable, that's why I didn't have that.
So this is what was given to the defendant by Sergeant Long, that's why it's in evidence. It was given to him by the witness, that's why it's in evidence, I think that's pretty clear.
Okay, the one that is marked as exhibit 2 is what was provided to Mr. Lawler by Mr.
In November
In
of 2023, correct.
Okay, and it is Mr. Muse's position that that was not the actual applicable presiding judge's order, because there was a newer one, and that's what, you're gonna have a chance to look at it and let me know if you have an objection to the court taking that in, judicial notice that was the applicable.
Sure, I'll file something if I have any disagreement.
Okay.
And Sergeant Long testified as such, Judge. He said
Well,
that
he read to a document that you said, I do know.
Your Honor, the Alaska Constitution guarantees wider Fourth Amendment protections than the United States Fourth Amendment, where, as to a person's interest in immunity from police interference, that's from Coleman 553, Pacific 2nd at 46, where the Coleman court held that investigative stops are permissible in cases where the officer has reasonable suspicion that imminent public danger exists or serious harm to persons or property had recently occurred. Sergeant Long testified that there was no public danger, that there was no serious harm to persons, that there was no serious harm to property. So under Coleman, he had no reasonable suspicion to detain Mr. Lawler. Sergeant Long testified that he was committing no serious harm. He testified that the Coleman standard is a flexible one. It must be evaluated under each case's circumstances. Judge, that's from State versus GB, 769 Pacific 2nd, 452, on page 455. That portion reads that to determine whether a stop is reasonable, the court should consider the seriousness of the harm which results from the criminal activity, the recency of the crime, the strength of an officer's reasonable suspicion, and the actual intrusiveness of the investigative stop. There was no recency to the crime because there was no crime. Lawler was processing a citation. He was filming. Sergeant Long testified that that in itself is not a crime. The strength of Sergeant Long's reasonable suspicion was non-existent because he testified he didn't know whether or not Mr. Lawler was authorized to record in the courthouse. He didn't ask. And the actual intrusiveness of the investigative stop is at its height because there's no deprivation greater than one's own liberty. And 2 more points, Your Honor, where the court in GB went on, where the alleged crime is only a misdemeanor, a minimally intrusive stop based on solid information indicating that a crime has just been completed may be justified. An arrest is not a minimally intrusive stop. It is quite the opposite. Your Honor, finally, the questions about the blowhorn and the sheep and the banging on the glass. I was bringing that up because of the case that defense believes controls here, and that is the case of Turney, T-U-R-N-E-Y, versus State of Alaska. That is 922 Pacific 2nd, 283. A 1996 case, that is a case where a defendant was convicted of trespass, and on appeal that was reversed. And on appeal, the court reasoned that the rules are different in a public place. First of all, the court held that a person being trespassed in a public place must be trespassed contemporaneously, meaning that you couldn't have done it in November because that was too attenuated. In this case, it was an attorney case. The defendant appeared on May 9th and came back on July 13th. And the court said that's not contemporaneous. So a 2-month and 4-day difference was not contemporaneous. Here we've got from November to February, that's a 3 month at least difference. So if 2 months was not contemporaneous, of course 3 months would not be contemporaneous. Your Honor, the court further held that even though in Turney, where the defendant was using a blowhorn, was banging on the window, yelling at jurors, disrupting the courthouse, he was doing all those things, and that was his First Amendment right to express himself, albeit not in the time, place, or manner that was prescribed by the court. That court did affirm Turney's disorderly conduct conviction. There is no disorderly conduct here. So the only issue that is relevant to us in Turney is that trespass, where the court held that a person must be trespassed contemporaneously to the trespass, essentially give them a chance to leave. And that's why I wanted to ask Sergeant Long, that in November you warned him of the trespass, he left. In February, you didn't warn him of the trespass and you arrested him. That's a violation of Turney. And Your Honor, because Mr. Lawler is a member of the public, he was in a public place, he was under compliance of Alaska law, he was under compliance of Sergeant Long's lifetime ban. Further, attorney says you can't have a lifetime ban, that's not a thing in a public place for trespass. Sergeant Long kind of alluded to that when he said you can show up to a medical facility even though you've been trespassing there before. He himself, Sergeant Long himself, caveated this trespass order to say if you're here on official business, testified that Mr. Lawler was here on official business. So under the law, where no person in charge personally informed Sergeant Lawler contemporaneously that he was trespassed, especially considering it was 3 months prior, and under Sergeant Long's own lifelong trespass, unless Lawler was present for official court business, which Sergeant Long testified that he was present on official court business, this motion to dismiss should be granted because even in the state's best case, there is not a law that supports a criminal trespass where Sergeant Long himself testified that recording in a public place is not a crime.
Thank you, Ms. Russo.
Thank you.
With that, Ms. Larson, do you want to?
Yes, Judge, two things. So I want to point to the court to, two cases here. So the defense is filing both a motion to suppress and a motion to dismiss. Their motion to dismiss is they're saying because there's lack of probable cause that you should dismiss it. That's not how the case law interprets it. I'd like to point the court.
They not even like probable cause, they say the elements are met.
Right, so I just wanted to point the court to Greenwood versus State, which is 2012 Westlaw 1994973, which in Alaska.
Never again, never again.
2012 Westlaw 1994973, an Alaska appellate court decision, May 30th, 2012, and that discusses Holstein, Scoos, and McCracken, and I cite Scoos in my briefing. The remedy for a lack of probable cause is not dismissal of the charge, it's suppression of the evidence that the court would find that was not supported by probable cause. The state is, of course, asserting that there was probable cause, but I just want to make sure the court is understanding that the defendant's requested relief is not how the case law interprets that. So if the court were to grant, again, we're arguing that there was clear probable cause, but if the court is going to say that there was a lack of probable cause, it's not to dismiss the criminal charges then. That's not the requested relief and how the case law treats it. That's Scoos versus State, Greenwood versus State, McCracken versus State, all of those courts interpret that exact question, Holstein versus State. They're looking at it in the DUI context for suppression of evidence. So, sorry, did the court have a question?
Yeah, here, what are you saying would be suppressed, whatever they found on the cell phone?
No, okay, so what I'm saying is, obviously we argue that there's probable cause, but in the alternative, the defendant's requested relief and the motion to dismiss is not how the case law treats it. You don't just get an outright dismissal of prosecution for the charges. The court would suppress what it would find would be fruit to the poisonous tree if the court finds that there's a lack of probable cause. But the requested relief of a dismissal is not appropriate. That's not how the case law even treats it as well. The court's actually looked at this argument many times at appellate court and said to the defendant, no, that's not what the requested relief is. You get suppression of the evidence, you don't get an outright dismissal. And I cited that in my motion as well, because I just wanted to
And if I suppress the evidence, then that means they don't meet the elements of the crime. It's not up to me to dismiss it, or?
But, no, Judge, and that's not how the case law has interpreted either. So that was one thing that I wanted to reiterate to the court, and then I also wanted to talk about Turney as well, because there's a clear distinction between the facts of Turney in this case. Turney was talking about being trespassed even for official court business. That defendant was issued a trespass saying he couldn't come there at all to the courthouse ever. He was protesting, they told him, nope, you can't come to the courthouse ever. That's what the Court of Appeals was looking at in Turney. Even the defendant being there for official court business is what he was trespassed on. This is not the case that we have here. Here, Mr. Lawler, he was allowed to go to the courthouse if it was for official court business. There was evidence today that he might have been there for a traffic citation. That's official court business. The state isn't disputing that. But what he couldn't be there for was to record. And that's why there is a criminal trespass charges being filed, because he was there on official court business, but he was recording, which was in violation of the trespass. It was a two-prong advisement. He was told that he could come to the courthouse only if it's for official court business, and even if he would come there for official court business, he couldn't record. That was a two-prong advisement that Sergeant Long gave him. And Turney is talking about a case where he was trespassed entirely, ever coming back from the courthouse. Court of Appeals says you can't do that, which the state agrees. It's a public place. Same with a hospital. Same with the post office, any type of public place. You can come back there if it's for official court business. So I wanted to talk about that because Turney is discussing something that's not applicable to what we have here. Here we have a caveat where he could come to the courthouse for official court business, and Turney was not considering that because that was not the advisement the defendant in Turney was given. So I just wanted to clarify that caveat with Turney. Thank you.
Alright, Ms. Markson, how long do you need to confirm that is the operative?
10
time
minutes,
did you say?
5-10 minutes.
Okay, so you'll file something by the end of the day today, if you're
Oh.
projecting.
Oh, sorry, okay, well, I have to get back to Palmer.
That's what,
Yeah, could I have till Friday? I'm actually starting a jury trial tomorrow morning at 8:30 SEC, so could I have till Friday?
any objections? So I'm not, you're starting a jury trial tomorrow?
Correct.
Alright, let me know by Friday at noon if you are going to object to the court considering,
Yep, will do. I'll just file something in writing if you don't hear anything by Friday, the state doesn't object.
and just confirm like where you found it and which so that I know where to find it.
Okay.
I don't think Your Honor needs this, but I just don't wanna leave it unresponded about this notion that Your Honor can't dismiss charges if they don't meet the elements.
I know how to read case law. Alright, anything else?
No, Judge, thank you.
Should we set a next hearing? So, I think we set it as a status, but if I don't agree and don't dismiss the charges, I think this case needs to be moving towards trial pretty darn soon. So, I'll set it for 30 days, which I think is my deadline for getting an order out, and that will ensure that I get my order out. And then at that point, that will be kind of a last status, and if I haven't dismissed, then we will be not looking at going to trial at all, okay?
Okay.
Alright, but status on May 22nd at 4 p.m.
Your Honor, may I appear telephonically for
You may. SAU working.
May 22nd at what time?
4 p.m.
Okay.
That work?
I think so. If it doesn't work for my schedule, somebody will call in for my office.
Okay.
We have scheduled pretrials, the court has been setting the pretrials on Monday during the Palmer block. And so I have over 400 cases that I sit in from 8:30 to 4:30 on Mondays, and that's why I haven't been able to call in, is because you've been setting them during the Palmer pretrial block.
Okay.
So I appreciate when you don't set it for a Monday, because that helps me out a lot, and then I don't have to try to find coverage.
Alright, we will do it on Thursday at 4.
And I think 4 p.m. is great as well, because, jury trials go from 8:30 to 1:30 in Palmer, so that way I can,
They do here too.
I should be able to call in on the 22nd telephonically. Thank you.
And if I have not said it, Mr. Visa, and as long as we're doing pre-trial issues, you can appear telephonically. If this case goes to trial, we're gonna find the Palmer courthouse, and that's like a courtroom Understood. All right, so we'll go forward with this, Jim.
Thank you.
I'll craft her for standing recess.
Not either. Okay. We have like down. Okay.
Yes, ma'am.
It was nice to meet you in person, Madam Clerk. Have a good rest of your day.
Well, you, drive safe.
Thank you, you too.